Assalamu alaikum. Inshallah, we will start the program. I have Uncle Mee's biography. I'll just present it in front of you. Uncle Meer was born in Hyderabad, India. He migrated to America to pursue higher education at Bradley University in Peoria, Illinois in 1962. According to his best recollection, he was the first Muslim student in Bradley University campus. His apartment 1023 North University in Peoria serves as a place of worship over 8 years where the students and handful of Muslims professionals conducted their Islamic activities. It's a great privilege for him to be a US citizen and an active community leader. His marriage was the first Muslim marriage in Peoria in 1971. He was blessed with 2 children, a daughter and a son. His son, Mir Yasser Ali, served in US Armed Force and received Purple Heart Award. Currently, Brother Yasser is a partner in one of the largest law firm in Chicago, Illinois. In 1976, Mr. Uncle Mir Ali changed his profession from civil engineer to estate and financial planning work. His main emphasis have been especially to educate Muslim immigrants with regard to estate settlement options pertaining to the law of the land versus Islamic Sharia obligations. He has conducted seminars for various organizations like ISNA, ICNA, IMA, SAAR Foundation, as well as many Islamic and non-Islamic organizations throughout the US. He serves many religious and non-religious organizations as a consultant, as well as being a board member. He is a humble servant of Allah and delivers pleasure in serving the people in need. With all this, I welcome Uncle Mir to go ahead with the workshop. Jazakallah khair.
Alhamdulillahi Rabbil Alameen, wassalatu wassalam ala Rasul al-Anbiya wa Mursaleen Sayyidina Muhammad wa ala alayhi sahbihi majma'in. Auzu billahi minash shaitan rajim, bismillahir rahmanir rahim. Wal asr, innal insana lafi khusr, illa allazina amanu wa amilus salihat wa tawasaw bil haqq wa tawasaw bis sabr. Sadaqallahu al-azim. I thank Allah subhanahu wa ta'ala for the opportunity to share with you one of the important commandments of Allah subhanahu wa ta'ala mentioned in Surah Baqarah, ayah number 180 and 182. And the advice of the Prophet sallallahu alaihi wasallam with regard to the men or women in Islam to establish Mashiach before their death. I like to thank Imam Mazhar and Aminullah for organizing today's program. Jazakumullah khair for their efforts. Before I start my program, I would like to remind you that for those who would like to have a follow-up meeting to have a further consultation, I have got the brochures here. Will planning guideline, and also that you have to give your information for your phone number, the time that you would like to meet, so that we can have next meeting, inshallah. It's not moving. Oh, okay. This is the forward. Yeah, okay. 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 The information being presented to you here is educational purposes, not intended to a legal investment and tax advice for your specific situation. Please consult your own choice of legal and tax professional and investment advisor. The topic of discussion that I have, number one, is basic estate planning, Islamic perspective of planning, importance of the Islamic will, responsibility of an executor, guardianship responsibility, durable power attorney, role of the living will, various use of the trust, benefits of citizen versus non-citizen. This one session that I have is almost cover 95% of the people. But however, that those people that who have over than $15 million, then we have to go through many other tools that we have to take care of that fund. As you can see that um, uh, okay, you can see that there are almost 170 uh, IRS tools are there for you to take care of Advantage. And mostly they're the people that who have uh, billionaires of this country take care of these things. So don't worry about it in terms of your own assets, as long as you take care of the advantage of what the government has provided. Many of these tools, inshallah. The Islamic perspective. The prosperity is an Islamic virtue. Wealth has a dynamic purpose for Muslims. Muslims' attitude to wealth is based on frugality. Planning is the heart of the Muslim way of life. A Muslim should plan for the present life that he lives in, as well as the life hereafter. I just quoted to you earlier that this Surah Baqarah talks about the will made obligatory before the death of any one of you who is leaving some property behind to bequeath it equitably to his parents and relatives. This is a duty incumbent upon the righteous, not an option for a Muslim residing in a non-Islamic state, but must have an Islamic will. As you can see that if you don't have Islamic will, then you are forfeiting your wishes to the law of the land, which is not in compliance with Islamic ruling. Prophet ﷺ also recommended that it is not a right of a Muslim who has property to bequeath that he should not pass 2 nights without having a written will with him. What is will? A document which takes effect upon the death of the person. This document has no virtues, no value by during life, but it takes effect upon death. Main ingredients of the Islamic will: proper Muslim burial, payment of the personal debt and taxes, selection of an appropriate executor, selection of an appropriate guardian, a special instruction for the executor and guardian to distribute the property in accordance to Sharia. In my 40 years of experience, I have seen the people who do not have the proper planning, that they have to suffer the consequences. For example, that if I have had an example where the person got married to a non-Muslim, is a Muslim brother that he married, a Christian, and they had the divorce. And they had children, and according to the court law, the court gave the children to the custodianship to the surviving wife. And what happened is that the surviving wife, being Christian, she has no obligation to raise the children Islamically. So that takes care of the problem if you have that in Islamic will that you are instructing to the executor and the guardian that whoever raise my children, they should abide with the Islamic law. Okay, so that's very important. And also that we had many cases where the distribution of the estate has been problem between the families. Sharia distribution upon the death of the person, 100% to the first layer of the recipient. Even in the Islamic state, wasiya will is required for the 100% choice of distribution. Who are the first layer? Living parents, surviving spouse, surviving children, share of the son and share of the daughter. Hadith of the Prophet ﷺ, a sick companion asked, "O Allah of Fazil, may I will all my property in charity? He said, no. The companion said, then I will, will half of it. He said, no. Then the companion said, one third. The Prophet ﷺ replied that yes, one third. Yet even one third is too much. It is better for you to leave your inheritors wealthy than leave them poor. Sahih Bukhari. So what is the one third and two third? You could have a bequest one third of out of property to somebody who are other than the first layer of the recipient. Like for example, you might have a brother, sister, or anybody, or charities. You could use that one. But remaining two third asset must be distributed according to the Quranic guidelines. Common method of estate distribution: allowing annual gift during life, lifetime exemption, beneficiary designation, joint tenancy ownership asset. This is something that majority of the people who have homes, they have in joint tenancy. Marital deduction provision, or you have an Islamic will, various trust options. Advantage of not having a will: asset will be distributed according to the law of the land. Creditors multiple creditors claim. Time delay is settlement. Cost of settlement is undetermined. It violates Islamic Sharia distribution. Allowable gift during lives: Sharia versus law of the land. Annual gift: Sharia has no hard limit as long as being mindful for the rights of the dependents and other beneficiaries. U.S. law: currently you could give $19,000 per year to whoever that you want, and $38,000 as a married couple can join giving that annual gift. Now, once the annual gift is only till December 31st, if you don't utilize that, then you forfeit that option. Sharia has no hard limit for lifetime gift or exemption, as long as being mindful of rights of dependent on other beneficiaries. U.S. law has currently is a $15 million individual. Unlimited estate transfer to spouse must be U.S. citizen. Treatment of benefit are not the same for non-citizen. What are those? Non-citizen spouse limitation. Limitation of gift provision is $194,000 currently. No marital benefit or lifetime exemption. No government benefit or surviving spouse. Permanent residency may be questionable. Many other concern problems. Joint tenancy is one of the titles that many people have used. It's 100% owner by two or more individuals during life as well as upon death. Joint survivor. Exemption of certain estate with community property. Major percentage of assets ownership held in joint tenancy in North America as house, auto, bank, accounts, securities. Advantage: joint tenancy avoids probate at death or joint owner. Surviving takes all right of ownership. Disadvantage: it bypasses Islamic Sharia distribution guide unless it is given as a living gift from the donor to the benefactor. And the tool that we have, the people use it. By directing asset into trust, you can help control how they are managed and directed, especially in case of you are incapacitated. The management of the trust will be uninterrupted and the power of the instruction are given to the co-successor trustee until once again you are able to manage your own affairs. It is a good document to pool many assets under the trust title arrangement. In many cases, it will reduce or avoid lengthy and multiple probate process. One more aspect is this, that people have multiple properties in different states. You could pool into one trust so that it would not go through each state's probate problem. Trust can be grouped into three main categories: irrevocable trust, revocable trust, testamentary trust, which is a part of the will be created upon death. What is the irrevocable trust? This trust may be used to try to reduce the value of your taxable estate Once it is created, it cannot be changed. Therefore, a careful consideration is required prior to transfer of any assets. Let me share with you what does it mean that it reduces the value. Means that if you have created a irrevocable trust and you have a home and you want to give it to your children under the irrevocable trust, that children will receive that property and you still get to live in there, but upon your death, that portion is out of your state. So they don't have to pay any estate taxes. And then what happens is this, that let's say, for example, a home you have given, say it was $100,000 when you gave it. And after 15, 20 years, the property of the house is overgrown. So it's already out of your state. So this is a good document to do that. But there are some problem. Assets of irrevocable trust are protected from personal lawsuits and as well as state and state transfer. Once you create this irrevocable trust, you cannot break it. There's a problem. You have to pay the penalty. You have to do this. So we have to be careful when you are creating this kind of trust. Advantage of revocable trust. Since it is revocable, you have the power to alter, amend, and terminate trust at any time. However, because of this power to revoke, the assets are includable in your state. Therefore, revocable trust do not generally reduce or avoid estate transfer taxes. Assets that are held in many states can be pooled into together. The successor trustee takes over the responsibility during your illness. The trust can hold the assets of a minor or disabled children. So one of the beautiful things that the trust is that since the children are minor, the assets are held in the trust till they are of their age. Testamentary trust. This document is an extension created in the will. A testamentary trust takes effect and becomes funded after the death of the testator. This document is usually created to hold assets in the trust upon one's death for a specific purpose and time, for example, for the benefit of minor children or college education purposes. Appointment of a guardian. This is a very important appointment that you have in order to make sure proper upbringing of minor children or reflect their faith, tradition, value, education, and other responsibilities. When you are appointing a person as a guardian, you have to make sure that that person is willing to take the responsibility because he has a fiduciary responsibilities to answer the court. Duties of an executor at a glance. You study the will, arrange for the probate of the will, assemble inventories and title custody of assets, review descendants' financial record, administrate the estate, consider non-profit assets, file all taxes returned. Distribution and managing the estate is according to the instruction of the will. Means that executor cannot do anything on his own. He is only following the instruction that you have left in your will, that he will follow those things. And if he does not do that, then he is subject to court problem. I cannot stress enough to mention that many people, when I do the planning, they jump and write the person or the brother or sister, this and that, without discussing with them that are you willing to take the responsibility. And there are some problem also. Like, for example, that in one case, that one brother had appointed his other brother as an executor, and upon the brother's death, the brother has to take care of all of those things, the financial affairs, this and that. Then there is his own domestic problem starts. His wife said that we have got our own problem by taking care of your other brother's responsibilities. So we have to be very careful that if you are taking the responsibility, that you are willing to take the responsibility. There is no compensation unless until you mention that if my brother is doing those jobs, that he he has a right to receive certain percentage of expenses. But that has to be mentioned in the will. Okay. Living will. Living will enable individual to make other own decision, ensure that others are aware of this decision. Usually this is done when a person is will to die, advance health directive, a specific type of power of attorney or health care proxy or advance directive. It is a legal instrument that usually is witnessed and notarized. Durable power of attorney. This is another document. A power of attorney authorizes another person to act on your behalf if you become incapacitated or unable to represent in person. This person may be anyone, including your family member, your friend, your lawyer, etc. What is probate? Many people, have worry about what is the probate. Probate is a legal process that a family must go through the death of the person. In probate, a judge appoints a guardian and executor, makes certain that debts are paid, establish clear the property, distribute assets under the court supervision. That's why that we know when you are making a will, you make sure that you appoint a guardian. Otherwise, you are leaving to the court. And you would not believe that court appoints an executor and a guardian. There's a huge charges that they're taken out of your estate. How to avoid probate? Giving away property during your life. Establish joint ownership of all real estate, because as you know, by virtue of the joint tenancy, the right of survivor means that whoever second person will receive all of it without any problem. Payable on death, all financial accounts. Use transfer on death securities. Take advantage of a small estate provision, less than 100,000. There is no probate on anything more than less than 100,000. So it's a good thing to utilize that. Use transfer of death, all real estate. Making a will, creating a living trust. What constitutes an estate? Many people have no idea what is estate means. And any individual owned which has material value, example, car, bank account, real estate, account receivable, stocks, pension plan, assets, and owned overseas. In short, even your last torn socks. IRS has a way of putting the value to every possible thing that you own. Main objective of financial estate planning: creating an estate, emphasis on accumulation; conserving an estate, emphasis on minimizing tax, investment, risk, and lawsuits; retirement planning, emphasis on maintaining individual lifestyle; distribution of the estate, emphasis on Sharia compliance, emphasis on minimizing estate transfer tax. Intention versus reality. Everybody had the intention that beneficiary of your choice. Upon my death, I would like to have my family will receive it, charitable causes, other choices with your will. Beneficiary, who are the beneficiary disguised? IRS first beneficiary of your income and estate. As you earn the money, you think that you are taking money home, but Uncle Sam is the first one to receive their share. Estate claims, probate, and other legal charges. Unjustified lawsuits. Reality versus default. Let's put together into some figures that the list of disguised beneficiaries we are talking about: federal government, income tax, capital gain tax, alternative minimum tax, social security tax, Medicare tax, estate transfer tax. Then you come to the state government. Income tax you pay, sales tax, municipal tax, property tax, gasoline tax, estate transfer tax, many more. That comes out to be about 55.6%. I round this one out to 50%. This is the case that people have, and we need to focus on how we can minimize those things so that you can send them more money to your families. The tax advantage strategies, shifting the personal higher tax by utilizing of tax advantage entities. As I mentioned to you, the tax advantage entities in IRS code is almost about 170. So I'm only using it, only a handful of those. Uh, minimizing the contribution into your pension plan, uh, maximizing children's college education, your 529 plan, creating a revocable trust account through allowable and annual gift. What annual gift that you have that you can create it, get it out of your state. Taking advantage of various tax shelter entities, annual gift, lifetime exempt, establishing CRT, charitable remainder trust. These are some of the tools that I have utilized it for many of my clients. And when you do this, you have reduced your personal income tax from 37% to maybe 15%. I put this one together for you to understand that what goes on. Asset distribution under Islamic will and testament. And I'm taking an example of husband dies. You know, that's something is a funny thing that, you know, always say that why don't you use it? Wife dies first, but you know that I'm using the example as the husband dies. So what happens? Then all of the assets that you have, this one, the example of husband living, gift surviving spouse, that they have a home already in a joint tenancy, any other joint assets like bank accounts, any miscellaneous gift, automatically upon the death of the husband goes to the surviving spouse. And whatever is left in here is burial expenses, payment of the outstanding loan, parents' portion, wife, Sharia, and marital deduction, and adult children portion, and follow the supplement of income. Like, for example, that you have minor children, or you have a trust inside the will for family trust, then your wife is surviving. So she receives till the minor children are grown, so that asset also goes to her. So you can see that she has not utilized everything the husband has, except that the things are paid to the parents and burial expenses and children's portion. It's the same thing that if the wife dies, the same reverse situation. This is the one that what happens if both husband and wife dies, and it happened that in one case that I was attending the SNA convention, and the family was coming from Oklahoma, and they had an accident. The entire family, husband and wife, died. And this is what happened when the remaining children, this is what happens. So it goes back to the common children trust till they become of the age. Increasing wealth comes to increasing complexity to manage one's estate. What is advanced financial estate planning? It is a continuous lifetime process, utilizing various tax advantage entities, protecting an estate from lawsuits and creditors. As we mentioned that irrevocable trust is one of the documents that it avoids the creditor's claim and lawsuits. It's very good document if you want to utilize it. Utilizing of assets control versus ownership, the smart management assets. This is one of the cases that I put together. This is the one that this brother was about $49 million worth. And we used various tools, as I've been talking to you about, to bring back the estate tax to almost 10%. And so it's a good thing to have a knowledge to see that all of these documents can be utilized and have a very knowledgeable planner to take advantage of these things. Key to financial success: acquiring quality education, maintaining good health. This is something for the youngsters I'm talking about. Okay. And investment of time and energy in productive life, utilizing proper financial planning strategies, or lots of inheritance from rich uncle. You have choices, right? Marrying rich a spouse or winning a big lottery. Those are choices you have. So you have to choose which one do you want to do. Reward of higher education. According to US Census Bureau statistics, people with a bachelor's degree earn over 70% or more on average than those with only a high school diploma. Over a lifetime, a gap in earning potential between high school diploma and BA is more than about $1 million. And you can see that this is one thing that college education never goes down. It's keep going up and up and up and up. So we have to plan accordingly. What is one of the plans that you have that, and I gave a lot of lectures into school, educating the people about this, because we are living in a fortunate country, United States, that if you as a student, your only job is to do good in school, have a good grades, and when you do that, you tap into that many of the grants and various other programs which are available. I'm not trying to brag. Two of my both children had a full scholarship, and I didn't have to pay anything for college education. So educate the children that that having good grades is can make your future. Does not matter what kind of job your father has, how much income he's making. Your job is to make good grades if you want to go to college. You have the lot of provisions there available for you to tap into it. What is the financial independence? Many people ask that, can you make the definition, what is the financial independence? The financial ability to walk away from the gainful employment with dignity and without worrying about future financial need. To maintain his or her financial lifestyle for the period of life expectancy as well as for the needs of surviving spouse. That's a nutshell of what is a financial independence mean. Why are you working? These are two things that you have to take in consideration. The most essential financial saving plan, one of the things is the 6 months energy fund, college education, family income support, retirement saving, and charitable account. Now, when people come to me, and I'm not trying to joke it, but this is how it is. They come with a plan, haphazard. Everything is just here and there. There's no coordination. So the job is proper planning requires a coordinated team effort, diversified resources, opportunities for halal investment. And when you do that, you put together all of that, and you save so much of wastage money into other areas. Summarizing the result, maximizing the protection and minimizing the cost, higher return, safety and liquidity, capital appreciation, risk and tax diversification. Your family has more money to receive rather than going into wastage to the IRS and other areas. According to our experience, the extra tax saving plan, the additional growth of assets resulting from the process, which I have just presented, when followed properly, could add up to millions. You are now among the informed people who do not act, lose as much as uninformed people who cannot act. Once those people who have intend to follow up with the meeting, then I have got this Islamic Will Preparation Guide. Is back in here. What does it consist of? This prepare you before you come in. What do you need to have to sign up your will. Handout instructions. Purpose of the handout is to prepare you what you should be included in your individual will. Recommended that each person should have one will for himself, one for copy to the masjid. Married couples should have mirrored image of their will. Selection of the guardian and executor for the choice. Having them fully understand the responsibilities involved in the executorship of the guardianship. Make sure that 2 witnesses during the signing of the will is present for a notary public. Execution of the needed document will take place for those individual who only has completed the handout instruction, checklist and ready to sign in front of the 2 witnesses of their choice. You should go through this because the booklet that I have, it gives you all of those checklists for to Islamic will and testament. This one is a current asset that when you have appointed an executor to take care of your affairs, he or she needs to know what is your current assets and liabilities. You need to jot down your current situation, real estate value, this, because upon your death, that poor person has to manage your situation. Second thing, that current family expenses need. Many people don't realize it, that when a husband and wife and a husband dies, the only thing that lessens the expenses in the house is a bowl of rice. The rest of the other thing that the surviving spouse has to continue to pay, gas and car payment, house payment. So you need to lay out those things so that executor should know what kind of financial affair that you have left, and when he is gathering all of your investments, he or she needs to know how to manage and how to invest so that he can continue to pay the surviving spouse the needed expenses. I have this is one that you should read this one because additional instruction and for Islamic will and testimony for your executor and guardianship. There are so many instructions are there, and if you feel that that's not enough, there is a page, empty page that you could add on to it. If you are interested in it, then we need to know your name and your phone, your address, email, and appointment date, so we can coordinate with your schedule and my schedule. Jazakallah khairan. Thank you very much. Any question? Yes. Please go ahead.
Assalamualaikum. I don't have a question, maybe a recommendation. If you could add more examples in your list, like somebody like me that want to see what are the options.
What option? Yes.
Yeah, not
see,
like
when you sit down, then we can discuss those things. Okay.
the problem is not one person, maybe it's the other spouses. Like, oh, why do I need it and stuff like that.
Yeah. For example, the people have assets overseas. Okay. We need to sit down and see what are the other options that we have. Now, as a citizen, no matter where you have your assets, you still be included in this tax purposes here. Okay. Or if you're coming from overseas, you already had the assets there, so you have to record that, so you would not be taxed again. There are ways you could manage it. So, okay. Any other question? Yeah. Brother Ibrahim.
Jazakallah khair. Yeah, about the irrevocable trust. So can the children later on sell that trust or still being held under that irrevocable status?
Can you explain what was that? I have a hearing problem, so go ahead.
So the unrevocable trust, can the children later on sell that trust or no? It's still unrevocable, still fixed. Nobody can change it.
So irrevocable trust.
Uh-huh.
Can the children sell it off later?
No, no, no. Irrevocable trust cannot be changed. It is established for the specific purpose, the benefit of the children. Okay, and there is a trustee who manages that. Okay, now let's look at that. They always say that you cannot do this, but there is always legal situation. Always have an answer. For example, in my case, one person has irrevocable trust, and he has two children. One of them already finished the college. Okay, the younger one is still there, but he needed the money to go to college for medical school. The irrevocable trust can lend the money to the surviving son, because the irrevocable trust has the benefit of both children, right? But the money is still there for the benefit of the surviving, but you give it to the surviving spouse with a note that when he has to pay it back. Yeah, but basically irrevocable trust, what the purpose you created. Like I have another situation that there is a person who have a disabled child. Okay, that's the benefit has to be paid for him child for the rest of his life. So those trusts are usually. It's called Cupid trust, qualified personal trust. Many people use that. I have had that one. That they don't want to pay the increasing value of the house. They were living in a very affluent places, $300,000 house. So how they can avoid it? They transfer the title of their house into the irrevocable trust for the benefit of the children. So there are many ways. It depends upon on your situation to do that. Don't be afraid to take advantage of the laws, because they are then meant only. Our average people do not know all of those things. The rich people are utilizing that one. Many attorneys who make these laws are taking advantage of that. So we need to be educated. We need to understand what is allowable, what is not allowable. Okay, there's always so many of the open. Any other question from the children? What is the question? He's asking a question.
At what age would you want us to write your will?
What is the age that you want a person to write a will? What age?
Yeah, it had to be adult age, and also if you have an asset. Okay, if you have an asset that you need to make a will, but usually it is an adult age. Yeah. Any other question?
What about? Yeah. Okay. What about a person who is not a U.S. citizen or not a permanent?
Give you the schedule. What are the schedule thing? Okay.
What about the person who is not a U.S. citizen or a permanent resident?
Okay. U.S. citizen, not U.S. citizen, it depends upon who is it. Your husband is not a U.S. citizen, your wife?
Both.
Both. So you have a restriction. As I mentioned to you, the only $194,000 given to the surviving spouse. Okay. If you do that for more than that, you have to pay tax on. Compared to $15 million for citizen, he can give it to his wife without paying any tax on. So when I started out working, the exemption was $60,000, gone to $15 million now. Okay, one of the farmers that I worked on, same situation. At that time, there was only 60,000. So there, anything over than that is a 43% tax. So idea is this, that don't worry about the state taxes anymore, but try to get the citizenship. or at least this is a solution. Cannot don't know what to do now. You cannot change. These tax laws are there for 300 years in the book. Even the George Washington, Elvis Presley, they did not have the will, and they had to go through this problem. So laws are there, and when a person dies, it's a closed chapter. As a matter of fact, in many cases that I had a problem that a person wrote a will under the deathbed. He was about to die. The court said that it's for anticipation of thing. You cannot do that. So you have to live for 2 more years. Yeah, these are the laws that they have got restrictions in there, but there are ways of avoiding those things, how to do that. So the best thing is this, that to educate yourself what the laws are and how you can utilize it. You have a question? Yes.
What if people have multiple wills? Like they have a will back home or something, and then
Pardon me?
what if you have more than one will? Like they made a will 20 years ago when they were in wherever, and then they move here. They don't even remember. What happens in that case? Do you
Is it
have any
Islamic will?
examples? Sorry,
Is it Islamic will?
I'm not sure. I'm just giving you an example.
No, in order for you to abide with the law of the Islamic law, you have to do the Islamic will. Okay, and that can be done. You can avoid the old one and you can have a new one. It takes over. Yeah.
If somebody claims that when a person is executing a will, and then someone else comes up with the old will, this is also a will of that particular person.
Mhm.
How does the law of the land dictates? Like
You write a new will and you have 2 witnesses and notary. It takes over the new will.
so, the date is the
Date and everything. Like for example, people they have a will when they had only one child. Then after you make the will, they have another child. All you have to do that in the back of the page that you have a codicil. You add it, and the 2 witnesses and notary, it becomes a part of the will. Yeah, it's not that difficult.
and how often we can update the will, like every year, or
As far as Islamic law is concerned, no, you don't have to do any changes. These laws are there. Okay, unless until you have your financial situation has changed. But the Sharia laws are the burial and all of those distribution of the assets are already mentioned in the Quran. So you cannot, if you want a Sharia distribution, then Islamic will is a suitable for you for the rest of your life. Okay. Any other question?
Any other question?
Yeah. Jazakumullah khairan. Thank you for your time, and I appreciate for your being so
Jazakallah.
candid hearing, especially Brother Ibrahim. He is my murshid. So mashallah, he came to give me the support. Jazakumullah khair. Assalamu alaikum.
And Uncle Mir, Jazakallah khair for presenting this, and inshallah we will have your schedule sent out, inshallah.
Yeah.
Assalamu alaikum wa rahmatullahi.
Inshallah.